Hello, my name is Esther Ayi. I am a partner at IPS Legal Solicitors in London. I'm going to answer some of the frequently asked questions that we get from clients. I'll do my best to answer some of the questions. My colleague Primrose has answered some of the questions already, and we are here to help you. So if you have any question or questions that are bothering you, feel free to contact us on the details that is shown on the screen, and we will do our best to answer your questions as much as possible. Very important question. We do get this question almost every day from clients. Yes, it depends. The answer to that question is yes, and it could also be no. Because when the Home Office changed the law in 2012, i.e. the immigration rules changed in 2012, then they introduced the 7-year rule, as we call it. According to the 7-year rule, if a child is born in the UK or lives in the UK for 7 years continuously, then that child can apply for leave to remain. Strangely, the law did not say that the parents can apply, but practically, if a child of 7 applies to remain in the UK, then obviously the parents can also apply. So that is approach taken. The 7 years is the starting point. When the Home Office introduced the law, it was just for 7 years. Meaning if a child was born in the UK and that child has lived here for 7 continuous years, or the child was brought to the UK and that child has lived in the UK for 7 continuous years, then you could apply. When the Home Office realized that most applicants were successful, they quickly changed the law, sadly, and they introduced a second aspect of the law, which means that 1, your child should have been in the UK for 7 years, or that child was born in the UK and has remained here for 7 years, and, listen carefully, and it will not be reasonable to expect that child to leave the UK. That is where the problem is. The law does not define what is reasonable under that particular rule. Therefore, the Home Office has a wide discretion. They determine what is reasonable. They consider certain factors. So the starting point for you is that your child has been here for 7 years, and that it will not be reasonable for that child to return to the country of origin, i.e. where the parents come from. So then the Home Office will consider whether or not one parent is from a different country, or one parent is settled here, or that maybe the child has a sibling who is a British citizen because that child has a different father. So there are so many other factors that the Home Office would put into consideration. So please, if you have a child who was born in the UK and that child has remained here for 7 years, or you brought a child to the UK and that child has been here for 7 years and you have no leave to remain, and that child also has no leave to remain, you can make an application, but don't do the application yourself. Gone were the days where applicants could do their own application and send it off to the Home Office. If you make a mistake, the Home Office will return the application and kindly ask you to resubmit it, or if you are refused, you have a right of appeal. The law has changed, sadly. If your application is refused under that circumstance, you might not have a right of appeal. So it is so important that you seek legal advice from professionals who are qualified. So IPS can help you. We can assist you in making such an application. That is another question that we get every day. We all know what has happened. Whether we like it or not, Brexit has come. The Prime Minister says Brexit means Brexit. So now EU nationals in the UK are in limbo. They don't know what the future is going to be. My simple advice is, until Article 8 is triggered, you can make your application. Continue to put in your application. If you're an EA national who is working in the UK, you can apply for a registration document. Your dependents or your family members can apply for residence card. At the moment, the Home Office is dealing with those applications. There is no indication that they will not deal with those applications as long as you meet the relevant requirements, i.e. that you are an EA national. You need to provide your ID to confirm that, and that you are working in the UK, or either you are self-employed, or you are employed, or you are a student, or you are seeking job. The Home Office will consider all those factors before your application will be dealt with. If you have dependents, i.e. a wife and children, or wife or children, they can also apply. Under the EU regulations, they have automatic right to confirm their residence in the UK, but you have to put in that application. There's a form for that and a fee to be paid. And once you meet all the requirements, the Home Office would grant your application. In our experience, we haven't had any issue where the Home Office is saying that because of Brexit, we are not considering EA applications. So my advice to you is that now that we haven't, or the UK has not triggered off Article 50, put in your application as soon as possible. We do not know the future, but there is an indication from the UK government that if the EU states can guarantee the rights of British citizens living in other EU countries, then UK is also likely to guarantee and confirm the rights of EU nationals who are already in the UK and working. So it will be wise for you to apply to confirm your right to remain in the UK. Legally, you don't need to make an application, but because of Brexit and because we don't know what is going to happen after Article 50 is triggered, you need to take steps, wisely to apply to confirm your right of residence. If you need help with putting your EA application, citizenship application, spouse application, or any other form of application, contact IPS Legal Solicitors. We are here to help you. We are passionate about what we do. We love our clients, and we are interested in getting results for our clients. So contact us. Our details are on the screen, as you can see, and we'll be more than willing to assist you.